Hi folks, so what I'm going to talk about today is an essay plan. This is focusing on the criticisms of the Human Rights Act and proposals for reform. So the first thing is, what kind of essay title could you get? Well, this one is discuss the extent to which the Human Rights Act 1998 protects citizens' rights and whether it is in need of reform. So for OCR, that would be a 20-mark question. Same rules apply. 8 marks for AO1 and 12 for AO3. So going through the AO1 first of all, I've made the point that the UK is part of the ECHR, and in 1998 it introduced the Human Rights Act. This came into force in the year 2000. So human rights are universal, based on being a human. The European Convention on Human Rights sets out many rights, for example, the right to life, the right to fair trial, freedom of expression, the right to a private life. So before 2000, a person who alleged a breach of their human rights could bring a case to the European Court of Human Rights, but they couldn't argue a breach of the ECHR in a domestic court. So they had to go to the European Court, which obviously there were delays and it wasn't as straightforward as going to a UK domestic court. So now a person can go to a UK domestic court, and for example, the Court of Appeal could make a decision as to whether your human rights had been breached. The other thing to bear in mind is an action can only be taken if there is a vertical relationship between the state and the individual, and that is Section 6 of the Human Rights Act. So it has to be you versus the state or somebody above you in the hierarchy. Section 2 of the Human Rights Act says a court must take into account past decisions of the European Court of Human Rights. Section 3 of the Human Rights Act, judges should interpret law in such a way to avoid incompatibility with the ECHR. And then there's a nice little quote, insofar as it is possible to do so. So incompatible Acts of Parliament can be amended via a statutory instrument, and that was stated in Section 10 of the Human Rights Act. The other thing that I would just put in for AO1 is the remedies available. Well, under Section 8, it talks about remedies, and you can have an injunction or damages, and sometimes just an apology or an acknowledgement that your rights have been breached is enough. In Bellringer, the European Court of Human Rights said the 1973 Matrimonial Act was incompatible with Articles 8 and 12. So what happened was that Parliament then amended the law with the Gender Recognition Act 2004. So there's quite a lot of AO1 there, and I'm sure there's enough for 8 marks. Now AO3, remember this is for your evaluation. So we're thinking about issues with the Human Rights Act. Does it need reforming? If we're going to reform it, what are we going to do? So, some good points about the Human Rights Act. It lets you go to a UK court. This saves time, it saves money. You know, the Court of Appeal, as I said earlier, could be the last court. You don't have to go to the European Court. So a person's rights are protected much earlier on, without all of the delays waiting to get to the European Court of Human Rights. And also, a lot of cases are declared inadmissible. They won't even be heard by the European Court. A next discussion point, you could talk about the fact that it places UK authorities and public bodies under an obligation to treat everyone with fairness, equality and dignity. It also gives you greater rights. It's safer to be gay. I mean, this was a crime in Northern Ireland until 1982, and it was decriminalised following a human rights case. In 2000, the army had violated people's human rights when they dismissed 2 men for being gay. So the Human Rights Act protects you, it protects minority groups. Things that have been criticised about the Human Rights Act is that non-UK judges in the European Court are deciding on UK domestic issues, and these are unelected, undemocratic judges. They were not placed there by us, the people. However, you have to remember that the European Court of Human Rights decisions are only persuasive precedent. So Parliament's supremacy remains, and the UK law remains sovereign. Human Rights Act is misrepresented in the media. You'll see the right-wing press refer to it as a criminal's charter, in that it gives criminals too many rights. It's seen as not being British because we are following the European Convention on Human Rights. And the other thing is, it's not an entrenched right. the UK does not have a written constitution. That means we don't have all of our rights written down in a document like they do in most other countries. So what could happen? Well, this is dangerous because it means that Parliament could repeal the Human Rights Act at any time, and this would lead to, well, this does lead to a lot of uncertainty. Now, in terms of reform, the Conservatives are very keen to get rid of the Human Rights Act. They would like to take us out of the European Convention of Human Rights and have their own Bill of Rights. So they said that, well, the UK would continue to respect rights in the ECHR, but we would have our own document that states our rights. They have also said that there would be limitations regarding immigration, which may involve redefining certain rights, such as a private life and degrading treatment. So I think that's a bit of a concern. The other issue that you could discuss is the 2023, so this year, 2023, illegal migration bill. So actually, if you look at the front page of the bill, Suella Braverman, the Home Secretary, has stated on that front page in the explanatory notes that she doesn't believe it's compatible with the Convention's rights. So this is quite dangerous. If we had a Bill of Rights, you have to think, well, would your rights be protected? Because even being part of the ECHR, the government are trying to get things through that do not protect your human rights. And in this illegal migration bill, they are suggesting that you can't have bail for 28 days. You have no right to judicial review. The government has said that a bill, having a separate Bill of Rights will, and this was their quote, help prevent trivial human rights claims from wasting judges' time. So that just shows that they believe that a lot of human rights cases are pointless. However, there's currently no timetable for MPs to start debating whether this Bill of Rights should be put into place, whether we should leave the European Convention on Human Rights. But yeah, this is a fast changing area. Politics, as we know, moves very quickly. So overall, I would then make a judgment as to whether you think the Human Rights Act is fit for purpose and whether it needs reforming or not. Personally, I don't think it does need reforming. I think our human rights are very, very important, and I would worry about what rights would be removed in a UK Bill of Rights.